Supreme Court has issued a contempt of court notice to General VK Singh. Meenakshi is on the phone line. Meenakshi, the Supreme Court, of course, yesterday had taken suo motu cognizance over the alleged contemptuous remarks that the former army chief made against the Supreme Court. So it is in this relation that the court has issued him a notice today?
Yes, absolutely. It will no longer be considered an alleged contemptuous remarks, mind you, at the outset. Let me clarify. It indeed is contemptuous. That is the view of the apex court of the country, and therefore, you rightly pointed out, on its own, which is suo motu, the Supreme Court had taken cognizance and listed the matter for deliberations today. And at the outset, as soon as the court convened, the Supreme Court was of the opinion that a notice to General VK Singh and the publisher of a media house has to be issued, and has given him opportunity to explain till the 23rd of October as to why contempt of court proceedings against VK Singh should not be initiated. That is the explanation that the Supreme Court has sought from the former retired Army General VK Singh. And also very significant here to point out is the fact that this is perhaps the second time that VK Singh has found himself on a sticky wicket, and
yes,
this time around with the apex court of the country. On an earlier occasion, it was the magistrates court in Patiala House where the case against him has been going on, where we saw the magistrate pull up VK Singh for repeated non-appearance before the court. But this time it is the Supreme Court of India which indeed has taken suo motu cognizance.
Meenakshi, could you take us through the comments that VK Singh had made? We know that he at one point did say that the court had not gone into the merits of the arguments that he had given on the issue during the proceedings.
Well, the part which has upset the Supreme Court of India in particular, you rightly pointed out, was General VK Singh's comments, which was carried by a media house. On the 22nd of September, there was an interview of VK Singh in which there was a quote pertaining to his case here. Now, you'll recall that VK Singh's age row in the Supreme Court, which the Supreme Court adjudicated upon and emphasized as to why his petition should be withdrawn. The VK Singh, on counsel from his lawyers at that point in time, had withdrawn his petition from the Supreme Court. But on the 22nd of September, the interview or the court which appeared of VK Singh's was to the effect that VK Singh had juxtaposed his case pertaining to his matriculation certificate and juxtaposed that the Delhi gang rape case, and had made comments about how a rapist was allowed to get away as a juvenile. That was the part which Supreme Court has taken objection.
Now, Meenakshi, this is the second time that he's invited the ire of the Supreme Court. Now, earlier on, also the court had asked him to either withdraw his comments or face a contempt notice. Now, this is the second time. This time, of course, the Supreme Court has been more strict. They have issued him a notice.
Well, yes, as I was saying, it was a suo motu cognizance, which means that on its own, Supreme Court has taken cognizance of VK Singh's remarks. We cannot refer to it any longer as an alleged contemptuous remark, because clearly the Supreme Court feels that the remarks have indeed been contemptuous, and a case for contempt is clearly made out. That is the reason the Supreme Court was seized of the matter on its own today, and clearly it has issued a notice. Now, this is very significant. That clearly means that Supreme Court has admitted the matter and is further going to deliberate on the merits of VK Singh's remarks. Also, what is significant here is the fact that this is perhaps the second time VK Singh has found himself on a sticky wicket. Earlier on, it was the magistrate court, you'll recall, where a defamation case against VK Singh is pending even as we speak right now, who had pulled up VK Singh for his repeated non-appearance before the court that point in time. However, this tryst with the apex court of the country could prove costly for VK Singh, because clearly now the Supreme Court feels that the remarks made by VK Singh, which have been published on the 22nd of September, wherein he made comparisons of his age row to that of the Delhi gang rape case, where he said that a rapist was allowed to get away as a juvenile on the basis of his matriculation certificate, has clearly not sunk in well with the apex court of the country.